Is it okay to disregard a notice to appear or NTA received in the mail? To begin the removal proceedings, Immigration and Customs Enforcement, or ICE, will issue a notice to appear, or NTA, charging an alien with being removable from the United States. There are many grounds for removing an alien from the United States, including the commission of a crime, overstaying a non-immigrant visa, or entering the United States without a visa. ICE may also issue an NTA if the alien misrepresented some material fact or used fraudulent documents in order to obtain an immigration benefit, even if the misrepresentation occurred many years ago. Once the NTA is filed with Immigration Court, the alien will be scheduled to appear for what is called a master hearing to determine the next steps. This first hearing is critical for the alien and can set the foundation for either a successful defense or a disappointing result.
Let's say now I've come to Reeves Associates. Now what is that attorney going to do for me?
Well, that attorney is going to meet with you first and discuss your case and make sure that you know exactly what you're facing and you know what you're going to be seeking. But the attorney is going to go to court with you, okay? And they're going to represent you in court. They're going to be sitting right next to you when you're facing that immigration judge. And they're going to talk to the judge and tell the judge whether or not you can remove this person or what kind of relief they're seeking. Many of our attorneys start a case off by saying, look, this person didn't commit the crimes they're saying they did, or did not lie, or did not overstay their visa, and that's what we call a contested removal hearing. So we're going to say, no, you can't remove us from the United States. Immigration just got it wrong. Or sometimes people do lie or commit crimes that you know, make them deportable or removable from the United States. And what that attorney is going to do is make sure that your client here at Reeves Associates, we're going to make sure that that person applies for the right form of relief to tell the judge, Judge, you may be able to remove this client, you know, of ours or this immigrant, but he's eligible for relief. Here's why you should not remove him, or here's why you should give him or her the green card that they're seeking. And so they lay out the plan that's going to go forward in trial. And that's all done at that master hearing. But then what really happens that you don't see in immigration court, what we do here at Reeves Associates, is the client then comes back, and the immigrant comes back to our firm, and we work together to provide documents to establish the relief. You know, a lot of it is a lot of documents, a lot of evidence to determine what's the best way forward. And so you work very closely with your paralegal and your attorney. And then when the hearing comes, which could be, you know, a year or so later, because these things take a while, they're presenting the evidence on your behalf, asking you questions, taking testimony, making arguments, filing briefs, all the things you traditionally think that an attorney would do.
You mentioned that Reeves Associates have been basically handling these cases since the 80s, or since 1980. So I assume then the experience you have is just, you know, can't be compared then.
Well, exactly. It can't be compared since we've been doing this for so long, but the variety of attorneys here at Reeves Associates is incredible. We have attorneys that are ex-employees of the State Department, of the Immigration Service. We even have attorneys who used to work for the immigration courts themselves. So these attorneys, it's not just one attorney representing you, a Reeves attorney representing you. You have the whole firm behind you. Even Mr. Reeves himself, you know, if there's any difficult case or a novel legal issue, we're meeting every week talking about cases, so you have a whole teamwork behind you.
Okay, well, let's talk about cost. You know, let's say nowadays maybe people are worried or scared that they can't afford an attorney.
What about the cost of not getting an attorney? What's the cost of being separated from your family for forever? And that's what deportation means to a lot of people. So you're going to have to weigh and balance. Sure, you could go with a less expensive attorney or try to even do it on your own. But at the end of the day, you've got to think, what's more important to me? Do I want to stay with my family? And if so, is it really, should I take a risk, or should I trust the most experienced attorney that I can obtain? And here at Reeves Associates, we know that attorneys, you know, they cost money. So what we know it's hard economic times as well. And what we do is, you know, there's payment plans available. There's ways that you can make payments throughout the trial court and proceedings, and many of our clients do. So I encourage you at least to go in and talk to an attorney and see whether or not you can afford to, or whether or not you really can afford not to take this attorney.
So I guess this is one of the examples of Reeves and Associates' commitments to immigrants and their families.
Exactly.
When an immigration judge finds an alien is illegally in the United States, this does not necessarily mean that they will be deported. There are many types of relief from deportation or removal that our experts at Reeves and Associates are well adept and familiar with these types of deportation scenarios that people commonly face. You can watch previous episodes and sneak peeks of up-and-coming shows by visiting www.immigrationexperts.tv. I'm Troy Montero, and remember to call your experts for your immigration solutions.